Everyone, very warm welcome once again to your favorite channel, that is StudyIQ IS English. I am your educator Praveen Mishra, and continuing the series of Indian polity, that is, we were on the chapter of the fundamental rights. We discussed till Article 14 into the previous lecture. So continuing the articles, okay, so as we were discussing yesterday's in the yesterday's session, that is about the basic features of the fundamental rights, including its importance into our community and society as well as the nation. And yes guys, here are my social media handles. If you want to connect with me over Instagram, you can connect with the name, that is Praveen Mishra _2107, as well as you can connect with me towards in my Telegram channel, that is study_with_Praveen. Okay guys, so whatever you are comfortable with, you guys can connect with me in here. So moving forward, that is till Article 14 we discussed yesterday till this point, and now coming to the next one, that is Article 15, prohibition of discrimination. What Article 15 states, that no person shall be discriminated only on the grounds of, there are 5 grounds that are mentioned, okay, that is here: religion, race, caste, sex, or place of birth. There shall be no discrimination, and the word here is only, on these 5 different grounds, okay, religion, race, caste, sex, and place of birth. But the very same article, in its further clauses like clause 2, 3, 4 and 5, it allows special provisions for women, children and socially and educationally backward classes. Okay, so as we were discussing yesterday, that is Article 14, equality before law. It has got a different component as well, that is equal protection of laws. With regard to that equal protection of laws, we have justified the provisions or the policy of reservation imparted to the section of Indian community. Okay, so this is where Article 15 comes into the picture as well, that is no discrimination only on the grounds of religion, race, caste, sex and place of birth. But on the very opposite side, the very same article, that is 15, in its further of the clauses, it allows for the special provisions. That is, this is something which is inspired through the concept of equal protection of laws. Okay, that is a special treatment, providing it to each and every segment of the society. Okay, from women to children to socially and educationally backward classes. And in fact, one more thing is to be added here through the 104th Amendment, 103rd actually, that is the economically weaker section as well. It has been added, okay, for socially, educationally and the economically weaker sections. Okay, they are also now given reservation. Okay, so this is Article 15. Next one into the list, Article 16, equality of opportunity in public employment. Whosoever I am, whatever my gender, my sex is, whatever I belong to, whichever place I belong to, whatever my place of birth or place of residence is, whatever my religion is, my caste, my community is, my race is, that doesn't matter. If there is any public office for which I am eligible, for which the only condition is eligibility, I can hold it. From Prime Minister to President to governors to police to administrative officer to revenue to whatsoever. From being a member of parliament to member of legislative assemblies, whatsoever is the public office is, I am eligible being the Indian citizen. There are some eligibility marks that I have to follow, there are some eligibility criteria that I have to pass. That's it. Okay, like who can become an IAS or IPS officer? Only the one who is the citizen of India. Coming from which religion? Any religion. Which region? Any region. Which caste? Any caste. Which color? Which race? Any of them. Okay. So there is no boundation to any citizens holding any particular set of office. Okay. Then it permits reservations for SCs, STs and other backward classes though. In its clauses, let's say for example, Article 16 Clause 4 talks about the reservation policy. Article 16 clause 4 capital A talks about reservation policy. Okay. So equality of opportunity in public employment. Just one thing that is to be marked here. Okay. Is this one. When we simply talk about Article 16 of the Indian Constitution, okay, all public offices are open to every Indian citizen. But there is a catch. There is a twist in the story here. There are few offices that are reserved or given to only a section of people or coming from a particular community or a segment of the nation. Okay? Yes, there are. And this is what is mentioned in Article 16 as well. Like for example, in the eligibility criterias, residence and religion could be a mandatory required eligibility criteria. For example, many states are there which do require local residents only in some certain offices. Like for example, in Maharashtra, we have this provision. In Karnataka, we have this provision. In Kashmir, we have this provision. In the states of Northeast, we have these provisions. That is, place of residence could be some eligibility criteria or part of an eligibility criteria. Then apart from that, religion could be also. Let's say, for example, if I have to become the teacher in a madrasa that is state funded, okay, then along with my educational qualifications, I must mandatorily be coming from the Muslim community only. So religion could also be a set of required criteria along with residence, not in all the offices, but yes, in some of the offices. Let's say, for example, Waqf board. Who can be the chairperson or the member of the Waqf board? It is mandatorily be a Muslim only, right? So this is what the logic is behind Article 16. So equality of opportunity in public employment, yes, but there are some offices that are reserved for specific people with regard to the eligibility criteria of residence as well as religion. Okay. So next, Article 17, abolition of untouchability. It actually disables untouchability in every form, and it also declares practice of untouchability as a punishable offence under the Civil Liberties Act of 1955. Okay. Then comes next, Article 18, abolition of titles. It prohibits the state from conferring any titles, barring military or academic distinctions and promoting equal social status. See, what used to happen in the medieval or the ancient ages as well in our country, that people, they used to get titles. Raja, Maharaja, Diwan, Savai, okay, Nawab, Nizam, okay, so Sultan, Raja, Badshah, all of these used to be the titles. Like Shah Jahan is not the name, Prince Khurram is the name, okay, but he acquired the title Shah Jahan. Okay, so Akbar is not the name, Akbar is the title. His name was Prince Muhammad Jalaluddin, but he acquired the title of Akbar. So in the very same sense, the titles were given into the British eras or the British rule. Apart from that, in the post-independence thing, when we come to the era of 1947, the Constituent Assembly made it very clear that we are making a socialist state, a state which will be fostering social equality along with the other components as well. So social equality can only become when each and every Indian citizen will be at par level. So providing titles would be, another stratification or classification of the Indian society. So that should be not done. Okay, and hence Article 18 came into the picture that talks about abolition of titles. So there is no Raja ji, no Maharaja ji, no Diwan Sahab, no Nawab Sahab, no nothing like that. Okay, everyone is equal. But there is a catch here as well. There is another twist in the story here in Article 18. That is, you can keep your academic or your military titles. Let's say, for example, if I am a lawyer, I can use the word advocate. If I'm a practicing lawyer, then I can use advocate as a prefix or suffix with my name. If I'm a practicing doctor, then I can use the word doctor as a prefix or suffix with my name. If I'm a chartered accountant, then I can use it as a prefix or suffix with my name. Just on, not on the official papers. It's not like that I will get my Aadhaar card and I will write advocate XYZ this, doctor XYZ this. No, not officially, in general. Okay. And apart from that, yes, if I belong to the military, from Air Force to Navy to Army to whatsoever, okay, the segment is, I can use my military titles along with my name as well. Okay, like for example, if I'm a lieutenant, commander, okay, or brigadier, major, whatsoever, whatever my position is, I can use it as a prefix or suffix with my name. But in general, not in official. It's not like that your Aadhaar card and PAN card will have the titles along with your name. No, in general. Okay, so Article 18, abolition of titles. And it has another good story as well. Can an individual accept the titles given by any foreign country? So what could be the correct answer, guys? What do you think? Come on, quickly. What do you think will be the correct answer? Can an Indian citizen accept the titles given to him or her by any foreign territory? Let's say there is a person, Mr. X, and there is a country known as Y, and that country Y wants to give any ABC title to this Mr. X. Can this Mr. X accept it? What should be the correct answer? Yes, come on, quickly go ahead. So, certainly no. And yes, both. So, how? What should be the answer? Yes, but on a condition. Only, yes, but only after taking the prior consent. Taking the prior consent from the President. From whom? From the Honorable President of India. That's it. If the President says yes, proceed, you can take it, then only an individual is entitled to take the title. But if the President in case denies, then that individual cannot with any particular machinery accept that title. He or she will have to deny it. Okay, so if any foreign government wants to confer any title, yes, you can take, but only after the prior permission. Before taking only you have to take the permission, not after. Okay, next comes Article 19, the 6 fundamental freedoms. What are these 6 fundamental freedoms all about? So it is freedom of speech and expression, freedom to assemble peacefully without arms, freedom to form association or unions, freedom to move freely throughout the territory of India, freedom to reside and settle in any part of India, and freedom to practice any profession or carry on any occupation, trade or business. Okay, so let's understand each and every one of it. As if you are watching our current affairs classes regularly, or all those particular independent sessions with regard to the hot topics of the day, then you must be aware that this is something that is evergreen, always and always in news, right? It is an evergreen thing, specifically in the present ongoing political vacuum that has been created throughout the territory of India. This is every time in news. As recently you are watching the Kunal Kamra case, how he has taken a jibe against the Deputy Chief Minister of the state of Maharashtra, and how he has, took himself into some trouble, some legal trouble as well. Okay. So Kunal Kamra's case or the Shreya Singhal case, okay, there have been many instances where the freedom of speech and expression was put to some capping by the state itself, and then the matter went directly to the judiciary. Okay, so freedom of speech and expression, the 6 fundamental freedoms guaranteed under Article 19. Okay, so do not take it as that this is the ratio. Okay, let me be very specific. Article 19, which talks about 6 fundamental freedoms. Okay, 1, 2, 3, 4, 5, and 6. Let's start with the first one. Freedom of speech and expression. I can speak anything. I can express anything. But let's just be very specific with the facts here. Okay, when we talk about freedom of speech and expression, speak anything, express anything as well. But how do I express myself? See, for example, painting is an expression. There are multiple, connotations to this word expression. Painting is an expression. Dance is an expression. Poetry is expression. Drawing is expression. Right? Sign language is an expression. And apart from that, anything like, for example, posting anything. Posting anything on social media, tweeting or whatsoever, is also an expression, right? So expression has multiple forms. Okay, so speech, yes, clearly mentioned, but apart from that, expression, okay, that is also having multiple aspects. Okay, so I can express and I can speak anything. But this brings us to discuss a very major vital element that is known as doctrine of reasonable restrictions. Okay, doctrine of what? Reasonable restrictions. So what is doctrine of reasonable restrictions? It says that the state, in order to maintain law and order, or could be security of the nation, simply speaking, the peace, the health, or the morality of the society, okay, just in order to preserve these things. It could be security and peace, it could be also national security, okay, internal security or the national security or anything, okay, interrelated concepts, okay. So in order to have the protection for all of these, the Constitution itself provides the state this authority to impose reasonable restrictions on the fundamental rights. On which fundamental rights? On each and every fundamental rights. For example, a restriction that we all have faced, all of us. Time flies with a great speed, and it has been now 5 years since we have witnessed or encountered the COVID-19 lockdown, when we were all, made not to move anywhere. Our freedom of movement was restricted. What was that? What was that lockdown? Was that lockdown not against the principles of our freedom of movement? Was it not violating our fundamental rights? Yes, simply speaking, it was violating. But constitutionally, it was not. Why? Because there is something known as reasonable restrictions. So, in order to maintain the health of each and every Indian citizen, the government had to create something that is known as lockdown. Okay? Your freedom of movement was restricted. Absolute restrictions were there. It was needed. And there, nobody could have, stated that no, the government is trying to be a dictator, blah, blah, okay, and they are restricting my movement. Yes, they did, but they did just for you, just for me, just for us. Okay, so this is what the concept of reasonable restrictions. Okay, a person who is having a disease which is vector-borne or communicable in nature simply. This communicable nature disease, person infected with such type of a disease, his or her movement can also be restricted. Okay. So there are certain reasonable restrictions that are imposed over us, over our fundamental rights. But the word here that is to be mentioned every now and then, that is, it should be reasonable. And what are the reasons? Here are the reasons. Okay. These are all the reasons, and these are all only the reasons, no further or extra sort of reasons they do exist. Okay, so freedom of speech and expression, I can speak anything I want, I can speak and express anything I want. But one thing I will have to take care in my mind always, that I cannot speak anything against the dignity of an individual or an organization. I cannot speak anything against the national freedom struggle, my national heritage, my constitution, right? My defense machinery, that is my army, my navy, my air force, okay, my commandos, my soldiers. I cannot speak anything against them, right? Because of them only I am alive, we are alive. Because the defense machinery is the most vital tool for our independence. Okay, so nothing against the liberty, the dignity of an individual or call it an organization as well. My constitution, my national heritage, my freedom struggle, and apart from that, my defense machineries as well. I cannot speak anything against them. Neither I cannot express anything against them. Okay, so this is what the reasonable restrictions are. Next, freedom to assemble, and here the reasonable restriction is itself mentioned, but assemble peacefully. Simply speaking, it is in general term what we can call it as right to protest. Okay, what we can call it as right to protest. It is to be made very clear concept, okay, that the protest word is nowhere mentioned in the Constitution. This right to protest, it is not written like this. It is written in this manner, that is freedom to assemble peacefully without arms. There is no mentioning of the word protest, but it does mean protest only. Okay, the constitution makers, they used this phrase as compared to this phrase. Okay, but obviously the reasonable restrictions are mentioned here itself, that is peacefully as in without arms and ammunitions, without weapons. So if you want to protest against anything, you have absolute authority, being the virtue or having the virtue of being the citizen of a democratic state. But the only reason, the only concern is that you must protest peacefully. Okay, that it should not involve any sort of violence. Next thing, freedom to form associations and unions, political, social, non-political, NGO, that is, okay, it's totally up to you, but it should be legal. You must not come to, with this stand that I want to create All India Association of Smugglers, syndicate of sharpshooters. No, prohibited. ऐसा नहीं होता, absolutely not. You want to create an organization, a particular association or a union, okay, but it should be legal in nature. Create a political association, that is a party. Create a non-political or a social association, type of a club or something like that. Create a NGO, legal in nature, okay? Freedom to form associations or unions. Then comes into the picture, freedom to move freely throughout the territory. Yes, move anywhere, but reasonable restrictions. Once again, there are certain reasonable restrictions that we need to follow. And what are these reasonable restrictions? Here are they. I have to follow them. Like the prohibited areas. What are the areas considered as prohibited? We cannot. The scheduled and the tribal areas, they are also prohibited for the general human movement. If you want to go in there, you can, but before that, you have to take the permit known as Inner Line Permit, ILP, from the authorities. Areas that are prohibited by the government, you cannot. Areas that are prohibited by the authorities, you cannot. Okay, or the areas that are also declared as the reserved areas, scheduled areas, tribal areas, there also you cannot. Okay, so freedom to move anywhere throughout the territory of India, yes, you can, but there is a condition. What is the condition? You have to follow the reasonable restrictions in case any of them are available. Okay, so does this movement also talks about freedom of movement also deals with, or we can quote it like that, freedom of movement. Okay, so where? Within the country. That is the territory, wherever we have as Indian territory. And next thing, it is talking about the freedom to move outside the country as well. Yes, within the country as well as outside the country. It is talking about both. And the case reference you can have, it is Maneka Gandhi versus Union of India case, 1978. Okay, here Supreme Court clearly stated that freedom of movement to move within the territory of India also comes with freedom to move outside the territory, outside the country. Okay, what happened with the Maneka Gandhi? Okay, Maneka Gandhi, she was waiting at the Delhi airport and she was about to take an international flight. But just before her flight, some officers from the passport authority, they seized her passport on the grounds of being, some kind of anomalies in the passport. And just because she was, her passport actually was confiscated by the authorities, she couldn't flew in that flight. And then it was the clear-cut case of the violation of the fundamental rights, and using her Article 32, that is the writ jurisdiction of the Supreme Court, or the constitutional remedies, what we can simply call it, Maneka Gandhi directly approached the Supreme Court of India. where Supreme Court stated that yes, the confiscation of the passport was on the invalid grounds or the unconstitutional measures were being followed, and then Supreme Court clearly Supreme Court stated that the person's or the individual's freedom of movement within the territory of India also implicitly explains the freedom to move outside the territory of India. Okay, so the case reference, please make it very clear. Okay, Maneka Gandhi versus Union of India. What is the time period? 1978. And what are the reasonable restrictions? Same. These are the reasonable restrictions. Just example, once again, the health conditions, COVID-19 lockdown of 2020 as well as 2021. Okay. Next. Freedom to reside and settle anywhere throughout the territory of India or in any part of India. Yes, we can reside and settle anywhere throughout the territory of India, but obviously not in those areas which are restricted by the authorities or the government. Okay, like once again, the scheduled areas or the tribal areas, these are the areas which are restricted. So you can settle, but not in the restricted areas. Like for example, we can understand it like this. What are the reasonable restrictions to it? The reasonable restrictions, they are, first of all, not in the scheduled or tribal areas. You cannot settle here. Okay, or any kind of a reserve area. If a person is infected with a communicable disease, then also the freedom of settlement or movement could be restricted. And apart from that, it is also stated by Supreme Court, if a person who is involved in any type of a flesh trade as in simply we can call it prostitution, then in order to maintain the morality of the society, okay, then also the individual's freedom of movement could be as well as settlement could be curtailed. Okay, so this is what freedom to settle anywhere, the reasonable restrictions they are. Okay guys, so remember, scheduled areas, reserved areas, person infected with a communicable disease, or a person involved in a prostitution or flesh trade. Okay, these are the simple restrictions with regard to Article 19, Clause 1, Subclause D, which talks about the freedom of settlement or reside anywhere throughout the territory of India. Then comes into the picture next one, freedom to practice any profession, okay, any profession or carry on a trade or a business or an occupation of your own choice. Yes, you can. Whatever you want to do, you want to become an officer, okay, you want to become a politician, businessman, cricketer, footballer, or any athlete, okay, you want to become a poet, a writer, an actor, whatsoever, okay, you want to become a corporate employee, a teacher, a lawyer, a doctor, whatever legal professions exists, whatever legal businesses exists, you can, without any terms and conditions. Okay, so this is what the concept of Article 19 is. Till 1978, there used to be not 6 but 7 fundamental freedoms. Okay, till 1978, right to property, was also there as a fundamental right under Article 19, Clause 1, Subclause F. But this right to property provision was repealed through 44th Constitutional Amendment Act of 1978. Okay, which one? 44th. Which articles they were repealed? Article 19, Clause 1, Subclause F, and Article 31. Okay, these are the two articles, okay, which were repealed through the 44th Constitutional Amendment Act of 1978. Okay, so till 1978, Article 19 used to have 7 fundamental freedoms, but because 19 clause 1 subclause F was repealed, and now it is left with 6 fundamental freedoms, and these 6 fundamental freedoms, they also do come with reasonable restrictions. Okay, next, Article 20, protection in respect of conviction for offenses. Okay, what is this? Let's discuss. So as you can see here, no person can be convicted for an act that wasn't a crime when it was committed. It prohibits double jeopardy, meaning one cannot be punished twice for the same offense, and it also protects against self-incrimination. Okay, this is what Article 20. Yeah, I know you guys are confused that ऐसा इतना लंबा चौड़ा लिखा तो है, अभी समझने को नहीं हो रहा. ठीक है, okay, it is written, okay, but I'm not able to decode whatever it is written or not able to understand clearly. Don't worry, that is what I am here for. That is what my duty is, to simplify the things. Okay, so starting with the first provision, what Article 20 says. Okay, just simply what Article 20 says. That is, no person, literally, no person shall be convicted until or unless that person has violated any law. Okay, that is simply has committed a crime, a violation of a law which is in force at the time of commencement of the act. Let's simplify this as well. No person shall be convicted until or unless that person has violated any law, that is committed any crime. Violation of a law, which law? That is existing. Not that law which is not existing, that will be created tomorrow, day after tomorrow, next month, next year, next decade, next century, whatever. No. Let's say today, for example, I am wearing a white color shirt, t-shirt. So, till 29th of March 2025, let's say wearing white color shirt, for example, just for instance, for example, 29th of March 2025, and wearing white shirt or a t-shirt, whatever, is not a crime, is not any sort of a crime. Okay, but let's say by next year, government will come and say that no, now we have formulated a law, and whosoever will wear white from 29th of March 2026, that will be, violation of law. Let's say, for example. Okay, so if a person is wearing a white t-shirt or a white color cloth only after 29th of March 2026, then only that person is subject to punishment. not a person who has wore a white color shirt or a piece of cloth before 29th of March 2026. Okay, I guess it is clear. This is known as ex post facto law. Ex post facto, or simply speaking, no retrospective effect. Retrospective effect, that is coming into effect from the back date. Okay, so it is having no ex post facto effect or no retrospective effect as well. A person will be punished for the violation of a law which is in force today, not a law which will be created tomorrow. Okay, please make this thing very clear in your notes if you are making. I'm sure you are. So no ex post facto law or no retrospective effect is applicable to the criminal laws. There are two types of laws, two types of suits, criminal and civil. So in criminal laws, no retrospective effect, whereas the Constitution says, okay, retrospective effect is applicable in civil cases only. In civil cases only. Okay, and never in criminal cases. Right? So this is how the things are done. No person shall be convicted or punished for a law that is not yet made. It will be made tomorrow, and tomorrow if you commit a violation for that crime, then only you are subject to conviction or punishment, not before that. Okay. Now, the other provisions or the other part of Article 20, what it says, no double jeopardy. No double jeopardy as in, what is stated here? No double jeopardy. That is, no person shall be punished twice for the same offense. I was watching this movie, Hindi movie, it is Andha Kanun, in case if you have watched it. So there is a very wonderful scene in that Andha Kanun movie. A court proceeding, a courtroom is there where court proceeding is going on. And there enters a person, goes in front of the judge, takes out a pistol, a gun, and shoots a person in the courtroom only, in the witness box, standing in the witness box. As soon as the person shoots the judge, sorry, not the judge, as soon as the person shoots that another person standing in the witness box, obviously the judge himself was the evidence there, was the witness there, police was there, lawyers, the advocates were there, the other people, they were there. So that person should have been immediately taken into the custody, immediately the proceedings would have been started, immediately the person should have been sent to the jail as well. But he was, let go. The judge said, okay, you can go, tata, bye-bye. So what does this mean? Committing a murder inside a courtroom, in front of the judge is allowed? No, absolutely not. The moment this guy shot the person standing in the witness box, immediately there was an uproar, and immediately judge ordered the policeman to arrest this guy. How can he do such thing, that too in front of me in the courtroom? Then the moment policeman was coming to arrest that guy, he said, no, Judge Sahab, you cannot arrest me. And Judge Sahab was like, why? And then Judge Sahab, the reason is that this guy whom I killed today, your court only, some 10 years back, sentenced me to 10 years of prison for murder of this guy. But the point is, this guy is alive. So today I saw him in your court, and I had a gun, and I came with this gun and I killed him. So the very same way, 10 years back when I didn't even kill him, your court only sentenced me to 10 years of prison, but this guy was alive. So I had, completed my conviction of 10 years, imprisonment of 10 years. and now when I came back outside and watching this guy alive, so I have killed him. Now judge was like, yaar, ye to cheating hai. This is unfair. You have committed a crime in front of me, you have done everything in front of me, and now you are saying that nahi aise nahi hoga. So the guy said, okay, you open the rule book and see. And then Article 20 comes with clause 2, that is prohibition of double jeopardy. It happens, it happened once as well in, I guess, I'm not so sure with the area, but a guy was given the punishment of this hanged till death. So the day of his hanging, there was a criminal who was given the punishment, that is the capital punishment, that is hanged till death. So the day when his hanging was about to happen, the moment he was taken into the cell of hanging, so the moment his neck was tied with the rope, and the moment the other guy pulled the lever, and when this surface opened, immediately what happened? The moment the surface got opened, that portal got opened, okay, and he got hanged, the very moment that rope through which his neck was connected, it got broke. But according to the rule book, hanging could be done only once, that is, punishment could be given only once. So his hanging was done, but the problem was hanging during the time the rope broke off. And when the rope broke off, now there is no scope of double jeopardy, and that guy was set free. Okay, bhai, okay, you go ahead. Now nothing can be done. Okay, so this is what the concept of double jeopardy is. Okay, so no double jeopardy, that is no double punishment for one single crime. And third one, no self-incrimination. No self-incrimination means you cannot be a witness for yourself. That no, Judge Sahab, I haven't killed that person. How? Who is the witness? What is the evidence? Me, myself. I have seen myself at that time, that is when the crime was happening. I was not here. I was in some other city. What is the witness? I am myself the witness. I have watched myself in that second city. Okay? No, not like that. No self-incrimination can take place. Okay? So this is what Article 20 is all about. Protection in respect of conviction for offenses, right? So guys, I think that will be enough for the day. Okay, so this is it till Article 20. We'll be discussing the rest of the articles in the next session. And guys, if you have liked the video, please do hit the like button, and please subscribe for the channel as well, and stay tuned with the latest updates, as our channel is 24 hours, I will say, that is providing you the fresh updates with related to the current affairs and the other subjects as well. Okay, so guys, stay tuned, and please do not forget to hit the like button and subscribe for the channel as well. Okay, so thank you so much guys. See you all soon in the very next session. And if you want to connect with me, you can connect with my social media handles, Instagram being this username and Telegram channel being this one, that is a Study with Praveen. So wherever you are comfortable, you can connect with me and share your doubts, and you can ask me to share